Good morning, Bruno.
Hey Nick, how you doing?
I'm fine, thanks to you.
So welcome to everyone. Welcome back, Nick. So today we have two questions as per normal. The first question, both are in respect of leases. So we're going to start with yours because it actually goes into a little bit more detail about what leases entail within the South African landscape, what the requirements are, that sort of thing. And then on my question, I'm probably going to end up applying a lot of these principles to the question itself. So next question, the facts around this is that somebody signed a lease and not realizing that they were going to be bound by the lease. They paid a deposit, then they tried to exit the lease. Unfortunately, the landlord didn't want to pay the deposit back. So this question is around the when a lease is actually binding, things to look out for. Things to look out for, all types of leases, the different wording that agents use when entering into leases. So Nick, maybe run us through that.
Perfect. So to start off with some fundamentals, South Africa has a common law system, which is just the historic use of law within our country. And common law sets out certain principles when it comes to particular agreements and particular ways of doing things. And what's important at common law is that there's a recognition within our common law that lease agreements do not have to be in writing between parties. So although the vast majority of lease agreements nowadays are concluded in writing, and we do encourage that, there are also recognition within our common law of what are called tacit and implied agreements. Now, these are lease agreements whereby parties have not necessarily signed a written document, but they behave in such a way that the law determines that there's clearly a lease agreement between the parties. So what do I mean by this? I mean simply that the landlord, in the circumstances, allows someone to use their property. The tenant is paying them a monthly remuneration or remuneration in some sort of form. And so the law recognizes that there is an agreement here, which is a lease agreement that has been struck between the particular parties. And once that the conduct between the parties can be established, it's deemed that there's a lease agreement, and then we apply principles of common law for how this lease agreement is governed. Now, obviously, with the incorporation of the Rental Housing Act, this has shaped our common law legislatively because it says there are certain terms that are deemed to be a part of this lease agreement, and there are certain things that you have to do if there is a lease agreement that is entered into between the parties. And what's important about the Rental Housing Act is there is now a provision within that legislation that says if there is a request from the tenants that the lease agreement is in fact reduced to writing, the landlord has an obligation then to do so. Okay, so while the legislation didn't create a preemptive obligation on parties to enter into a written agreement, there is an ability for a tenant to request that the lease agreement is actually reduced to writing. Okay, so with that in mind, okay, we now turning to the question with regards to, well, when does a lease agreement start? How do we know this thing's been concluded? Okay, and as I've said to you, this can depend on a couple of things. So the first thing is, let's look at the party's conduct in the circumstances. So if there has been payment of a rental which has been accepted by the landlord, so the landlord doesn't say, no, I don't want this money, and the landlord lets someone utilize the premises, those elements will demonstrate to us that a lease agreement has come into place in the circumstances, and we look at the conduct of the parties. This common law position can be amended within written documents between the parties. Okay, so very often when you sign a written lease agreement, it's going to say when a starting and an ending date is, and now you'll look at, did the parties actually sign the document? And further to that, what can also be done in written documents is very, clever lawyers have written in provisions within written lease agreements that dictate when a lease agreement shall come into effect. Okay, so something very important to look to when you are looking at a written lease agreement. Is there a dictation on when this lease agreement will actually come into place or not? So very common provision which is used is saying that the lease agreement won't come into effect until, for instance, this lease agreement is signed by the landlord or until a deposit is paid. Okay, so if those provisions are contained within the lease agreement, there is some condition upon which the lease agreement needs to occur in order for the lease agreement to start, then that is the standard that you're going to look at in the circumstances. Was this particular condition that is set out within the lease agreement actually met? And then you can assess, well, the lease would have started from that particular circumstance. So it entirely depends on the facts of the particular case. But what is important to note is there are a couple of different things that we look at to see, was a lease agreement in fact entered into in this particular case? And that is how we determine whether the lease has been entered into or is not actually entered into a circumstance.
Awesome. Thanks so much, Nick.
Perfect. Thank you. And